Hello, everybody. What a wonderful house, and it is so great to see you. I am Jeffrey Rosen, the president of this wonderful institution, which is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And what a better mandate to have as we talk about this most contested of all questions, namely the Supreme Court nomination process and whether or not the Constitution compels the Senate to have up or down votes on nominations. There are many important things to talk about tonight, but we're going to start with the Constitution and take it out from there and see where it goes and learn a lot together. Before I do that, I have a few plugs. Just today, we've added 2 new documents to our main exhibit. Jackie Robinson's signed contracts. The Philadelphia recently apologized to Jackie Robinson for the discrimination he faced, and these historic documents that led to the breaking of baseball's color barrier will be on view through Saturday, June 5th. Please come see them in the permanent exhibit. Thank you very much indeed. Next week, June 1st, you've been at the edge of your seats, I know, thinking of nothing else but that riveting event, the Brandeis book launch. The book was out, and I was just in Boston yesterday, in New York, and it's out, and it's so exciting to talk about it, and I literally can't wait to tell you all about the great Justice Brandeis. Tickets to the live event, I think, are sold out, but there are seats available for the simulcast, and if you really want tickets, then write to me, and we will find a way to get you in, because I'd love to have everyone there. June 6th, Sidney Blumenthal and Lentz explore the role that party politics have played in America's struggle for economic equality, a fascinating program that will cast interesting historical light on our current vexations. On June 8th, Intelligence Squared returns for a debate about whether the president has usurped Congress's congressional power. June 13th, Cass Sunstein, Star Wars and the Constitution. You and I will find out at the same time. And on June 16th, Jim Obergefell, the lead plaintiff in the Supreme Court case that gave the right to marry to same-sex couples, will be here. And we culminate this stunningly exciting season on June 27th with the hot-button topic of reproductive choice and the Constitution, what you need to know. Okay, now I will introduce today's guest, and I should say I'm speaking from these new microphones, which seem to be working pretty well. The sound system had been a little iffy, and for your listening pleasure, we have new mics, and I hope they're going to continue to work very well. Josh Blackman is an associate professor of law at the South Texas College of Law and associate scholar at the Cato Institute. Michael Gerhardt, the NCC's own scholar in residence, is the Samuel Ashe Distinguished Professor of Constitutional Law at the University of North Carolina. Timothy Lewis is a mediator, arbitrator, and settlement counselor and former judge on the U.S. Court of Appeals for the Third Circuit, where he was previously served on the U.S. District Court for the Western District of Pennsylvania, appointed by President George H.W. Bush. And finally, I'm so delighted for the first time to welcome to the Constitution Center one of the great constitutional scholars of all time and a dear friend, David Strauss, Gerald Ratner, Distinguished Service Professor of Law at the University of Chicago. Please join me in welcoming Josh Blackman, Judge Lewis, Michael Gerhardt, and David Strauss. There we go, sure. This is sort of like constitutional Jeopardy. Come on down. It's wonderful. This is perfect, I think. Very good. Yes, very good. Okay, so we have a lot to talk about, and we are going to begin with the text, as always. We're going to begin with the text of the Constitution, and we're talking now about Article 2, Section 2, which says, "The President shall nominate, and by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court." Josh Blackman, you have argued that the text does not compel the Senate to grant up or down hearings of any kind. Tell us why you believe that that is so.
So it's a pleasure to be here at the National Constitution Center with my good friend Jeff Rosen. So we are in the Constitution Center. We should talk about the Constitution. And the Constitution says, he shall have power by and with the advice and consent of the Senate to nominate judges to the Supreme Court. Now, in the law, shall means must, so the president has an obligation to appoint a justice to the court. Advice and consent, though, what does that mean? It's up to the Senate to decide what to do. And the Senate has the power to adjust their own rules. And under the rules as they stand now, the process is if we want to move ahead, we hold a hearing. If we don't want to move ahead, we don't have a hearing. That is within their power. The Constitution is entirely silent on whether the Senate must take any steps whatsoever. I've argued in the past, this is what we call a political decision and not a constitutional decision. The Constitution is silent on this important point. It's up to the Senate to decide whether to leave the seat empty, whether to put someone in, or say, hey, nominate someone else, or do nothing at all.
Wonderful. Wonderful in setting us off so well.
Point for Blackman.
Excellent, I think, is the better adjective. Or thank you, that might be the best way to say it. Okay, Michael Gerhardt, on this purely textual point, does the Senate have a constitutional duty to have an up or down vote? What is your view?
I don't know that the Senate has a constitutional duty, but although let me also hasten to give my gratitude as well for being able to appear here today. It's always a terrific opportunity to be at the National Constitution Center in front of the best audience in the world.
On a non-bipartisan basis.
And I just, in the thank you department, Michael has moderated. You've come to know him as a guest moderator. He's done such a phenomenal job, that John Quincy Adams event. And then last week, he was on that panel where Ken Starr made news in the New York Times. That was front page news, where Judge Starr here at the Constitution Center expressed empathy and some generous words for President Clinton in his presidential service. So thanks to Michael for moderating, and now thanks for being a panelist.
Well, thank you. I don't know that I can say anything quite as earth-shattering as he did, but we'll give it a try. So I don't know that you could argue that the Senate has an obligation, a constitutional obligation, a constitutional duty to give a hearing. The textual language is interesting. I might just point out just very quickly that critical word "he" that we glossed over for a second. It'll be interesting to test that perhaps this fall. But we'll come back to that later. In any event...
Sorry, is there any argument that were the president to be a woman, the Constitution would not be translated?
Well, I hope not. But it may be one of those areas in which the framers' foresight was limited. Yeah. In any event, the language is... the critical language we're going to wrestle with right now is the language about advice and consent. And one of the other arguments that's often made, and we can hear today, is that one of the critical aspects of that language is the Senate gives its advice, and its advice may well be what Josh just said. Its advice may well be, we're not going to go forward. And there are a number of ways in which the Senate may choose through delegations made to committees and delegations made to its leaders not to have further hearings, but the notion that the Senate doesn't have an obligation doesn't mean that the Senate lacks discretion. It's all about Senate discretion. And the very fact that the framers placed the responsibility in political leaders means that they're going to have to be accountable for the choices they made, whether to go forward or not to go forward.
Great. David, I want to turn to you for a moment, because you've written a series of influential and important articles parsing this notion of advice, at one point suggesting that some consultation in advance between the Senate and the President might be helpful. Tell us first, on the textual point, is there a constitutional obligation to hold hearings or up or down vote? And then how would you parse the word advice?
Well, thanks, Jeff, and thank you for inviting me to this great institution. Thank you also for your gracious words in your introduction. I guess I would want to disagree with my friend Josh Blackman about the text, but I really want to make a different kind of point about this issue, which is this, and it's an especially important point for a magnificent place, this magnificent place, which is any institution requires more than a rule book to operate successfully. Any institution of any complexity, whether it's a workplace or a university, or for that matter, a family. It's not enough to say, well, here are the rules, and as long as you stick to the letter of the rules, that's fine. There have to be understandings and traditions and ways of accommodating each other. And if that's true of your ordinary workplace, which it is, work to rule is an aggressive thing that employees do. It's a form of industrial action. If that's true of a workplace, it is certainly true of a complex institution like the United States government. And the understanding has been, it is an essentially unbroken understanding, is that while the Senate is entitled to reject a nominee. The Senate it would be unprecedented, literally unprecedented, for the Senate to say, yes, this president was elected, but we choose to hold open the vacancy on the Supreme Court so that this president's successor, if we like the successor, can fill that vacancy. That has never happened. The Senate has never done that. Now, can I prove to you that as a textual matter, the Senate cannot do that? I think the textual argument is much more open than Josh thinks it is, but that's really not the point. The point is that when these understandings have developed over time, they need to be maintained. They tend to be fragile and they need to be maintained. And I have to say, Jeff, what really worries me about this situation is the kind of thing you mentioned where the Senate and the president cooperate and the president goes to the Senate beforehand and says, here's the list I'm thinking about. Is there anyone on there you can't live with? And the Senate says, well, yeah, that guy, we can't live with that guy. Anyone else, we'll think about it. That sort of understanding will break down. And, if the Senate does not confirm Judge Garland and a Republican is elected, it is a certainty that the Democrats will do everything they can to prevent that Republican president from filling that vacancy. If the Republican president succeeds and then 4 years from now we have the same scenario we have now, which is possible, it's a certainty the Democrats will do the same thing the Republicans are doing, and that's how the constitutional system erodes.
Judge Lewis,
Yes.
I want to ask you, you are the only one of this distinguished crowd who's gone through a confirmation hearing. You were appointed by George H.W. Bush in 1991. Describe your process, and was there consultation between the Senate and the president? How'd you get the job?
Actually, before I answer that, let me join my colleagues in expressing my gratitude for being here. We should note that this is, as I said earlier, the 229th year plus 1 day anniversary of the Constitutional Convention right across the way here, and we should observe that and be grateful for what we have and what we are now today struggling with, because at that convention, while advice and consent was discovered and placed in the document, how that actually would unfold and what the parameters of that would mean was left out. So I will tell you how I got the job, but first let me just address what was just discussed. We are talking about the tension between a constitutional duty and a constitutional obligation. And there is tension because the document is silent as to what the obligation is. There is not a justiciable duty in the textual language of Article 2, Section 2 that requires the Senate to hold a hearing. It is not there. But with that said, I must agree with David. Implied in the document, I believe, and I think most people who have thought about this and written about it believe, is an understanding that the branches of government will cooperate with one another to ensure that they work and that they function. And while this is not, as I said, a justiciable duty spelled out in Article 2, Section 2, it's clear from our practice, our tradition, that the advice and consent process does involve the Senate doing certain things. Inaction can be interpreted as action, so the Senate has acted through its inaction. I think that our history and our traditions, our constitutional history, is better than that and speaks to something deeper than that in terms of its obligation. David made reference to a common worker and a family and how things are that are not explicitly spelled out are just understood and over time become traditions, and they become a matter of our honor and our decency in how we function. Without the cooperation of these institutions of government, we fall apart and the Constitution loses its meaning. So I'm with David. Now, how did I get my gigs on the federal court? That was at a time when senators actually talked to one another across the aisle. there was a different level of, there was a different conversation, there was a different dialect, for that matter. When I was nominated for the district court, John Hines was a senator from Pennsylvania, and Arlen Specter on the other side of the state. And these were people who, in the mold of Hugh Scott and Dick Schweiker and some of the other senators that our Commonwealth has produced on the Republican side, spoke freely and worked well with their Democratic colleagues. And and Senator Biden, of course, was chair of the Judiciary Committee at that time, and was rational, reasonable, and about the business of trying to see to it that the president's wishes, to the extent that they did not constitute anything extreme, were advanced as the duly elected president of the United States is entitled and it is expected. And so it was a non-controversial time in that sense. I recognize that I was nominated on the heels of the Clarence Thomas hearing, but that was different for reasons that we know. And it was also different because then Judge, and soon to become Justice Thomas, represented an ideology that was, through his writing and some of his speaking, this is Anita Hill off to the side here, was maybe on the far reaches of conservatism. And so his ideology became very significant, but it obviously was like throwing a gallon of gasoline on the fire when Anita Hill was discovered. So then I was nominated for the Third Circuit the following year, and once again, politics certainly did come into play a lot more in that nomination, but there was a more rational and reasonable discussion happening in the Senate at that time. It is just very different today. The culture is very different, and for that, we should be deeply concerned, and I personally am deeply saddened.
Thank you so much for that. All right, I'm detecting Josh and Mike to some degree saying there's no constitutional duty, and the judge and David saying, although maybe not a formal duty, certainly a norm of comedy that compels some kind of compromise. So with that in mind, just to try to even things up, Judge, I'm going to ask you to sit here next to David.
I'm going to take my stuff
I think
with
I'll
me.
feel a little bit better. It's a long trip, but it'll just balance things out a little bit here at the nonpartisan National Constitution Center.
You look great, too.
It's beautiful, absolutely. It's a magnificent tie, which blends beautifully into the color of your suit. And Josh.
Notice the red tie, by the way. This was a tell.
All right. But
Not an accident.
So Josh, we've talked about the text. Now I want you to make the case from original understanding and practice. I think that you have written that both as a matter of original understanding, there was no obligation or even expectation that the Senate would hold hearings, and a matter of practice, there have been many nominees who have not granted hearings. Tell us about those 2 points.
I'd be happy to. So the phrase advice and consent that was drafted about a block that way was not pulled out of the ether. In fact, the Massachusetts Constitution of 1780, drafted by John Adams, had the phrase advice and consent in it. And it was a very common practice of the Massachusetts legislature that if the governor appointed a figure they didn't like, they would simply do nothing. And that would be their advice and consent. So I have text, they agree. I have history, they're going to agree. So let's talk about practice, which is always where we will disagree. I don't know that the history is quite so rosy as Judge Lewis makes that to be. There's a man by the name of Robert Bork, whom Mr. Biden did not treat quite so well. The Bork hearing, I think, is the starting point of where we find ourselves today. Perhaps for those who have been following this closely, it's like, my God, where did this Supreme Court controversy come from? Let me give a brief history of the Supreme Court since Robert Bork. Robert Bork was indeed a conservative, but a brilliant one. He was a law professor at Yale. He actually taught constitutional law there. He had a record as a Solicitor General, as a circuit judge, and as a very well-respected jurist by all accounts. But you know what? He favored the original meaning of the Constitution. He did not accept the Supreme Court's precedents that didn't adhere to that. And you want to know what? He told everyone that. He said exactly what he believed, and for that, an eminently qualified judge, he was voted down. They rejected him. Why? Because he wouldn't uphold the precedents of the Warren Court that people liked. Fast forward to Clarence Thomas. That hearing, as Thomas said, was a 20th century lynching. that because he read Richard Epstein's works on takings, he was no longer qualified to be president. Let's fast forward to the year 2000. The law professor by the name of Bruce Ackerman at Yale, who argued that because President Bush was illegitimately elected with Bush v. Gore, all of Bush's nominees should be blocked. And indeed, throughout the 2000s, men like Miguel Estrada and others, Bush judges were blocked. They were never given a hearing at all. I don't recall any events held of why that was so awful. This has been ongoing. And let me give you a more recent example. I'll work Justice Scalia, I promise. The National Labor Relations Board, not nearly as important as the Supreme Court, but it's a 5-member board. Democrats blocked President Bush's appointments to this board. When the White House changed, Republicans blocked President Obama's nomination to this board. So what happened? President Obama made recess appointments to this board during a 72-hour break. That had never been done before, to make a recess appointment during a 3-day break. The Supreme Court unanimously said, no, you cannot do this. But what did the Obama DOJ say in that case? Look, we have intransigence. We have this gridlock. We can use this power to get around this gridlock. And the Supreme Court unanimously said, no. These structural features are in our Constitution for a reason. Justice Scalia wrote that gridlock is a feature and not a bug of our Constitution. When the political parties don't get along, what Mr. Madison designed was that stuff doesn't happen. We do not have a parliamentary scheme where a simple majority wants something and moves forward. We have these checks for a reason. And until the American people perhaps agree, and I would love for us to agree more on things, until we agree, this is what we get. We get this sort of gridlock. This is how our Constitution operates. Perhaps there'll be leadership to bring us forward. I have no hope for that to actually happen, but things are working as they were designed. We've just finally reached a point where those those checks kick in.
Thanks for that. Now, that was a powerful statement. Before we have some people who are jumping to respond to the post-Bork experience, but before we jump squarely into that, I want to take another beat on the history. Mike, Josh said he's sure that everyone is going to agree about the original understanding and the history. You've written a lot about the history. You've said that politics have always influenced appointments, and this is no different than how Democrats obstructed some of Tyler's judicial nominations, and Democrats blocked Fillmore's efforts to fill a Supreme Court vacancy. Tell us, let's stick to the 19th century, just so we are in our comfort zone here. Tell us, to what degree did 19th century presidents actually have their nominees get up and down votes, and how bad was it back then?
Oh, sure. Quote me. That's
yeah. Well, I've got it right here, I'm sure.
Well, I think, so there's one thing, of course, I think we will all agree, and it's in some ways the launching pad for all this, and that is that the Supreme Court is politically constructed. No matter what else we think, the very fact that the Appointments Clause vests the critical authority in presidents and senators means that they'll make political choices and political decisions. It is certainly true. In the 19th century, there were moments when the Senate actually considered a particular nomination and didn't act on it, but there are a couple things to keep in mind. The first is the longest vacancy in Supreme Court history is actually occurring right in front of us. If the Senate fails to act on this nomination before the next president comes in office, you will have been able to witness the longest vacancy in which there has not been, in which nobody was able to fill it.
Is it right that until now the longest wait was Brandeis, 125
exactly.
days?
Yeah.
And of course I'm running the numbers for my book flagging. I think July 19th will be the point where Garland surpasses Brandeis' record.
So whatever happened in the 19th century, it didn't drag on as long as what we're experiencing now, or may be experiencing in the near future. The second thing is, if I can leap ahead a little bit historically,
not too far.
but not too far, is if we go back 100 years, if you look at the last 100 years, every nominee to the Supreme Court has actually gotten a hearing, except for 2. And the only 2 that didn't get a hearing were the 2 that were withdrawn. So this is also a reminder that the history doesn't necessarily support complete and utter inaction for a long period of time. The last thing I would just say is, while we spend all this time talking about history, we should really understand that history doesn't bind us. We are not bound in any way, shape, or form by past choices that people made, which brings us back to the fact that our leaders should be held accountable for the choices they make now.
Great. Judge, I know you're chomping at the bit to respond, but I want one more beat on the ancient history. David, you talked about this norm of comedy of the Senate and President sort of sagely consulting each other. But there were some bitterly contested nominations from the beginning. Adams is elected. The Federalist Senate literally reduces the size of the Supreme Court to deny Jefferson the right to make an appointment. What is your take on that 19th century history, and how does that reconcile with the more collaborative ideal that you're arguing for?
Oh, I think it is, Jeff is right. Of course, it's absolutely the case that there have been pitched battles over the Supreme Court, pitched political battles over the Supreme Court. And I'll give you a hypothetical scenario for today's circumstances. If President Obama had picked out, I'll give you a hypothetical nominee, a liberal law professor who has spent his career vigorously criticizing the Roberts Court, the Rehnquist Court, and the Berger Court as being too conservative. Even the Warren Court is a little too conservative for this hypothetical law professor, but an undisputably highly qualified, professionally qualified, extremely smart liberal person. If President Obama had nominated that person, I think it would be entirely within the rights of the Republican Senate to say, not on our watch. You're not going to get that person on the Supreme Court as long as we have a majority in the Senate. I think that's the way these checks and balances are supposed to work. I think it would be entirely within their, by the way, I just described the Bork controversy, just flipping the sides, that's all. That's just the liberal Robert Bork, who I just described. And the Democratic Senate said, not on our watch. The Senate, the Republican Senate, would be entirely within their rights to say to the president, no, we're not going to confirm that person. We want someone who is, we can't get our person, but we want someone who is more centrist. In your party, you're entitled to appoint a Democrat, but we've got to confirm someone unless they're more centrist. Someone like, what name comes to mind? Merrick Garland. Someone like that. So I think it is absolutely right. They're political. There are political controversies, there are political issues. But the fact that it's politics, I don't often disagree with Mike Gerhardt, and when I do, I'm usually wrong. But I mean, I don't know if I'm disagreeing here. To say that it's politics doesn't mean there's not a right and a wrong. To say that there's politics in the background, the senators and the president still have duties. That's what it means to live under a constitution. That it's not just what can I get away with politically. It's what does this system, what duties does the system impose on me, to go back to something Jeff said a little while ago. And I think the Senate, although you can't find this spelled out in the text of the Constitution, the Senate has a duty, even though it's a political fight, to establish certain boundaries and not simply to do stuff because they can get away with it.
Great. Okay, Judge, the floor is yours to respond to Josh's sort of post-Bork history, and just to put the question starkly, what about the claim that since Bork, it's just been getting worse and each side has been escalating, and here we are, that it's neither side is worse than the other?
Josh was right about some things.
And wrong about others.
Yes, he was wrong about something. He was right that on, to be very specific about it, September 17th, 1787, the Constitutional Convention did adopt the Massachusetts Compromise. This was a compromise that was the result of efforts by James Madison earlier with the proposal that he had made, and a proposal before then by James Randolph from Virginia, to do certain things that would have configured the nomination process a certain way. Massachusetts' practice was that the governor would appoint, with the advice and consent of the upper chamber, justices. And so that approach was adopted, and from the very beginning, ideology was taken into consideration in blocking nominations. John Rutledge, one of President Washington's nominees for the Supreme Court, was blocked because of his opposition to the Jay Treaty. So it's not new, and it's not news that ideology comes into play, and it's continued through the centuries. I think, as a friend of mine, who I was talking to my colleagues here about in the green room, a friend of mine named Josh Blackman was speaking about this recently, and I agree with what he said. I think that there was a collision that occurred in the 1980s between forces that inevitably resulted in the pitched battles that we are now seeing. It started really with the Warren Court in 1954. And by the way, Earl Warren did not even appear for his Judiciary Committee hearing. not even appear back then. And my point there is that the process has evolved over time. The tradition has evolved over time. How we do Byron White's hearing in 1962 lasted 15 minutes. He was asked 8 questions, and he was confirmed the next day. So it has evolved and it has changed. But how did we get here? The Warren Court changed the status quo of the United States of America. And suddenly, the United States Supreme Court became a crucially important institution in the daily lives of Americans, and thus in the lives of politicians. When the infusion of meaning into the Civil War amendments, the 13th, 14th, and 15th Amendments by the Warren Court, and what resulted during the 60s and the 70s and the civil rights legislation and so forth, affected Americans very, very directly, and the court as an institution became very important. And so ideology became very important. And this is what happened with Bork. And I think that was a collision between that history and the meaning of ideology to nomination process. Do I think that it's good that Miguel Estrada was blocked for the D.C. Circuit? Of course not. Even Seth Waxman and a number of other former solicitors general testified on his behalf or submitted letters on his behalf to the Judiciary Committee saying they would not have turned over the information that he was being asked, and that was the basis for blocking him, which was unfortunate. I think that it's good to have. I think that a duly elected president of the United States is the people speaking, the people have already spoken, and the Senate's duty is then to determine whether or not the nominee is fit for that office. And of course, some ideology must be taken into consideration, but it's gotten completely out of control, beginning with Bork, moving forward. And I think that the effort that we are seeing today, contrary to the view that, well, this is necessary because to do this in an ugly political climate is only going to make things worse, is in fact making things worse, to refuse to do it.
Great. Okay, Josh, I don't want to get into a tit-for-tat argument about whose fault it was, because we've heard that things have been getting worse since Bork. What remaining constitutional arguments can you muster against the claim that there's a duty to have hearings? Some scholars have looked at the Appointments Clause within the broader context of separation of powers and said that the Senate can't act in a way that threatens the Supreme Court's ability to function, that really undermines it as a functioning branch of government, and the Constitution prohibits that. How can you respond to that on constitutional terms?
So I think this even goes before Bork. So let's talk about Roosevelt, perhaps the most pitched nomination issues in the history of the court. During the 1930s, the Supreme Court invalidated a number of FDR's New Deal programs, most famously Brandeis in the case of Schechter v. Poultry, a 9-0 decision invalidating the National Recovery Act. President Roosevelt said, well, we can go one of two ways. We can amend the Constitution and give the central government the power to enact these various regulations, or we can just change the composition of the Supreme Court. He chose door number 2. He announced his so-called court packing scheme that would allow him to nominate a new justice for all the other justices of the age of 70. This was the apogee of injecting politics into the Supreme Court nomination process, the apogee. Ultimately, it never went through. As the story goes, Justice Owen Roberts decided, you know what, I'm going to give this one up. I'm going to uphold FDR's progressive laws. I'm going to switch my vote. So Roosevelt never had to do this, but Roosevelt bragged about how he basically beat old man Supreme Court. He bragged, he boasted about this. For a very long time, the Supreme Court has been intricately woven in the political nature of our government. And now we're at this bizarre place where Scalia's seat can be replaced by a Democrat, right? When George H.W. Bush wanted to nominate David Souter, you know what? They were kind of thrilled because he wasn't that much of a big deal. Won't maybe adjust the court too much to replace Brennan. But now we got Scalia's seat. This is a big deal. I'm not trying, and don't get me wrong, to say that there's a right or wrong here. I think any argument made out of political is genuinely bad faith. Any sort of political argument is generally bad faith because with the shoe on the other foot, I don't hesitate for a second that Chuck Schumer and a senator or whoever will be saying we need to wait for the next election. I don't hesitate for a second to think that would be the case. It just so happened that Scalia died at this moment. So this is a system the framers gave us. The framers gave us a political process, and the process is playing out. Now, will this matter for the next election? No. I saw recent polling asking both Republicans and Democrats, list your top 5 issues facing the nation. Was the Supreme Court in either list? No. Jobs, the economy, immigration, whatever. This is a fairly low-level item which people aren't going to vote on. People who care about the Constitution, the Supreme Court, are in this room for the most part. But that's about it. So this is a political process. It will play out politically. We're going to have a shorthanded court for a while. Maybe we can talk about that later. But textually and historically, there's nothing to stand on. All you have is say we have to stand on tradition and precedent, but at every juncture, as politics ratchet up, those traditions are discarded by the wayside, and this is the inevitable consequence. In fairness, before Scalia passed away, I've been speaking about this topic for a while, and I called something the Clint Eastwood effect, right? That we would have an empty chair, right? Remember Clint Eastwood? I've been saying this for years, that the next nominee, we're going to have an empty chair for a while. I'm on tape saying this. So this was an entirely foreseeable consequence of Bork, of Roberts. Lest we forget that Barack Obama filibustered Sam Alito. He tried to block Alito's nomination. Everyone's in bad faith here. No one has clean hands. And I don't know quite how to fix this going forward.
Okay, we'll maybe talk about fixing it in a moment, but Mike, you've heard the arguments so far, and I think Josh pretty succinctly just made the case about why there's no duty to hold hearings. He said it's always been political, it's been getting worse, the precedents keep changing, and both sides have dirty hands. Do you have a constitutional response to that? Can you muster from text, history, practice, precedent, something to respond to his claim that it's all politics?
Well, it is politics, but, and in fact, David, you and I will agree, but politics merely defines the playing field. And so if we're on that playing field, we still have to make choices. We still can make judgments about normative judgments about what's good and what's bad. Let me actually make an even stronger argument, I think, than Josh made, and then I'll rebut it.
Okay.
We call that a straw man.
Right. Not yet. I haven't made it. So the argument is that the death of Justice Scalia created stakes over this nomination that are enormous. The next appointment, whoever fills it, is going to make a transformative appointment. Will define the majority of the court, and it is a principal position to maintain that we will not see anybody we will not allow anybody to fill this unless they have exactly or a similar ideology as Justice Scalia had. That could be a principled argument. But there's one thing that's missing in a lot of the examples that have been given, and that is almost everybody we've mentioned that got denied a seat was given a hearing. And that isn't the case here. We've lacked the opportunity for a hearing in this particular circumstance. And so whatever happened over the last 100 years, everybody else got a hearing. And actually, with all due respect, the most pitched confirmation battle in history didn't happen after the New Deal came about. It was the thing that Jeff just wrote about, Justice Brandeis's hearing. 6 months of contested hearings, which did focus in part over his ideology, did focus on the future of the Supreme Court, and
his religion.
And his religion. It was enormously anti-Semitic. He was confirmed, but the reason I mention that is because Justice Brandeis got a hearing. And this is in part, we can acknowledge the huge stakes here. I think the Constitution makes that possible. But at the same time, we can ask ourselves, can we do better? Can we do better than what we're doing now? And I think the answer is yes. President Lincoln said he would make an appeal to our better natures. I think the same thing happens today. Can we do better? We had hearings during world wars. We had hearings during Civil War. We can have a hearing now. And I think that's what the Constitution makes possible.
Great. There's phenomenal questions, as always, from our wonderful audience. And I think I should jump right in, actually, so we have time, and then we'll tie some other stuff up in a moment. The first question says, Does a Senate delay of almost a year set a precedent that the Senate could block a president for his or her entire 4-year term of nominating? Doesn't this essentially make the public the fourth branch? And David, I'm going to ask that to you, because assume that well, I'll just ask the question to you.
I think the question makes an excellent point. I mean, if we're going to say, well, the Senate can advise and consent, or it can withhold its consent to a Supreme Court justice, what's to prevent the Senate from withholding its consent to a Supreme Court justice for the entire 4 years? In fact, I'll go one better than that. Senior executive branch appointments also have to get the consent of the Senate. What is to prevent the Senate from saying, we don't like this guy who was just elected. We're not going to confirm any of his nominees, any cabinet positions, any diplomatic positions, any position that requires Senate confirmation. We're not going to do it because we just don't like the fact that he was elected. What's to prevent that? On the logic that's being used to defend what the Republicans are doing now. And I think that just shows why you have to rely on understandings about the way the system works and the way the system ought to work.
You can chime in, Judge, and imagine if President Trump wins, would the Democrats be justified in refusing to confirm anyone for 4 years?
I'm not going to sit on the stage and think about President Trump.
On a nonpartisan basis. This is called a hypothetical, Judge. Imagine that a hypothetical president called Trump wins, yes, and it's a Republican. Would the Democrats be justified in refusing to confirm for 4 years?
No, and I'll give you a different hypothetical to follow up on David's point. I'm sorry, I don't understand what's going on with the mic. I hope you can all hear me.
These beautiful new mics.
Yeah.
No, do speak into that so everyone can hear.
This gets back to what I had started out with about an implied duty or an implied obligation in the document itself that each branch of government will work in cooperation with others to ensure the proper function of our country, of our nation. Suppose, for example, heaven forbid, but suppose 5 justices died within 2 months of one another, and the Senate said, a majority in the Senate said, you know what, we're not going to confirm any new judges. The majority that's there now is what we like, and we're going to leave it that way, and we're not going to do anything further. Now, I do wonder, David, whether there is I said earlier, this is not a justiciable duty. I wonder now whether we are moving into the field of the justiciable duty. I wonder whether or not that could be litigated and what the constitutional parameters of that question might be. I don't know the answer, but I do know that we are talking about honored traditions. You mentioned earlier that for the past 100 years, every nominee has had a hearing. It's actually for the past 125 years, every nominee has had either a hearing or a vote. This is unprecedented. And to suggest that, well, it's not written in a document, and so it's okay, and this is politics and so forth, is to fail to understand the meaning of taking an oath to uphold and defend the Constitution of the United States. Each senator and each justice and each president takes that oath, and a part of that duty requires a cooperative effort among the branches. And that's why I believe that whether it's in the original text or not, it is there. And history supports that, our traditions support that, and our effort to be better supports that.
Great. Here are related questions about the effect. Yikes.
Drop the mic. We're
President
done
Obama
here.
did
We're
that
done.
at the end of the White House Correspondents' Dinner, so you could do the mic drop,
mic drop.
and that's really impressive.
Fitting after what
Exactly. Judge out, and then there we go.
Constitution out.
But we want to bring the Constitution back in, and that's what we're going to do with this great new question. The effect of this delay. One member or guest asks, if the present court hears 12 cases and all result in 4-4 decisions, how does that affect the functioning of our democracy? And a related question says, are these judicial vacancies crippling our judiciary? Is that relevant to the current discussion? Does the Senate have an obligation to act? So I guess I'm asking you, first of all, Josh, are these 4-4 decisions or the unanimous decisions where the Supreme Court has actually encouraged both sides to seek compromise a sign of the paralysis of the judiciary, or does it show the court is functioning fine?
Okay, so show of hands. Last year, how many times was Justice Scalia in the majority in a 5-4 decision? Who thinks more than 10 cases? More than 8? More than 6? The number's 5. Okay, so about 75 cases last year. Of the 5-4s, Nino was in the majority only 5 times. He wasn't in the majority very often. Last year was a particularly bad term. So is this crippling for the Supreme Court? Maybe for the cases that Jeff and I and others care about. But for most cases, it won't matter. Most cases are 9-0. Do you want to know where obstruction has made a difference? In the lower courts. Right, Judge? In the lower courts, there are judicial emergencies where entire districts lack district courts, judges. Circuit courts are behind because of the same issue of blocking nominees and blocking hearings. This is not limited to the Supreme Court. But I want to make one other broader point about your future guest, Cass Sunstein, if I can give a plug. He also wrote, in addition to Star Wars, an article called Partyism. Does anyone know what partyism is? So we have a lot of isms in this country, right? Racism, sexism, whatever else. Partyism is hating people because of their political party. Now let me give you an interesting metric. Every year, a study is done where they ask, would you be okay with your child marrying someone of the opposite race? Okay? Thankfully, that number is going down. That is, more and more Americans are tolerant, saying we will be okay with our kid marrying someone of the opposite race. Another question is asked, would you be okay with your kid marrying someone of the opposite political party? That's going up. So while racism's going down, partyism's going up. What we have here, this judicial crisis, this is not the root of the problem. This is a symptom of a much bigger issue. As a polity, we do not like each other. We hate those we disagree with. How can you expect the Supreme Court to ever function and to be nominated when this is what we have, right? So for all the people in Washington saying, oh, you're evil politicians, they're reflecting their constituents. The people in Washington are elected by the American people, right? People forget this. It's very easy to vilify members of the Senate, but they're elected. They have constituents, and they've made a judgment this is what their constituents want. So this is a symptom, not the root of the problem. Until we diagnose the root of the problem, these conflicts will keep popping up.
Judge, you've written about the paralysis in the lower courts. Do you agree with Josh that the effect of this obstructionism is felt as much in the lower courts as at the Supreme Court level?
I will agree with that, but I will disagree with everything else.
I'll take it. I'll take what I can get.
Josh just actually, in making the argument that Justice Scalia's vote didn't really make that much of a difference, undercuts all of the rationale for blocking Merrick Garland to the Supreme Court right now. If Justice Scalia's vote didn't matter all that much, then what's the problem with granting Merrick Garland a hearing and confirming him to the Supreme Court? But beyond that, I will say that it is true that the vast majority of cases that are resolved in the United States Courts of Appeal throughout the country are final. They do not require the Supreme Court to say anything more. That's for the vast majority. But you know, even if it's only 4 or 5 cases that are affected by a 4-4 split, what if one of those cases was Brown versus Board of Education? What if one of those cases was going to dramatically affect the life of every single person in this room and out there? That's enough. The Senate should do its duty.
David, do you foresee that President Obama will withdraw Judge Garland's nomination if he's not confirmed before the election, if a Democrat wins the presidential and Senate elections, to allow a more liberal nomination by the new Democratic president?
Well, I'd just be speculating, but my speculation is that this president will not withdraw the nomination. I think the president's decision to nominate Judge Garland was very considered, very deliberate. Remember, he took some criticism from liberals, people to his left, who said, Judge Garland is pretty centrist. He's probably not going to be confirmed anyway. Why don't you appoint someone who is much more liberal and will, as the saying goes, mobilize the base? And President Obama decided not to do that because he thought that's not the right kind of appointment to make in these circumstances. He thought someone like Judge Garland, who was older and recognizably less liberal than a lot of the other people who were on the short list, was the right appointment. And I think President Obama will stick with that nominee. Now, once President Obama is out of office, if a Democrat is elected in November and takes office on January 20th, I think you'd have to expect that whoever is elected then would get her own choice about
or his
about who the next Supreme Court justice would be. I don't think if there is another President Clinton, I don't think she would feel any obligation to continue with President Obama's nominee. But I don't see President Obama withdrawing it. I don't see President Obama playing any games with the lame duck session, saying, "Oh, well, now we're going to put someone else up." I just don't think that's in his character. I mean, there's this idea out there that President Obama is kind of aggressive and uses the powers of the presidency with abandon and goes too far. And in fact, I think that is totally wrong. I think it's a slander. And I think the way he's handled this nomination is an example of that. And I think he'll continue to do it because that's the way he thinks, that's what he thinks his duty is. Not to play politics, but to do the right thing for the Supreme Court.
Please clap.
This isn't the Supreme Court, so I'm not going to ask you not to clap. I'm just maintaining my steadfastly nonpartisan status here. Josh, let's play out the what-if scenarios a little bit. Assuming that David is correct, that President Obama will stand by Merrick Garland for as long as he's in office. There's a technical question of whether he'll have to renominate him after October 30th, when the nomination may expire. But assume, for the sake of argument, that a Democrat wins on November 4th. Will the Republicans change their tune and confirm in the lame duck session?
No. So I think the Republicans have made their position and that they've stated very clearly that the next president should appoint the justice, and I think they'll stick with this. So I think it's highly unlikely that the Senate confirms Garland lame duck. The other variable is that the Senate may remain Republican. So even with a President Clinton, you may still have a Republican Senate. And that still gives them some leverage over whom to nominate. So let's talk about something else, which is the nuclear option, right? We haven't mentioned this. Traditionally, a filibuster, right, means you need 60 votes to debate something, right, to get past that initial block. And traditionally, circuit judges had that threshold of 60. About a year and a half ago, Senate Majority Leader Reid used the nuclear option. What does that mean? The magic number for circuit judges and lower court judges is now 50. So as it stands now, the 60-vote block is still in place for the Supreme Court. That means you still need 60 votes from a nominee. To the Clint Eastwood effect, I can see very possibly that if Republicans control the Senate, Merrick Garland doesn't get the 60 votes. And then we have a really sticky pickle, right? That's if they actually have a whole day and vote him down. That's also interesting. So that's why I don't think they're going to be hurried to nominate him quickly. The other issue is, say the Democrats control the Senate, and say it's President Hillary Clinton. They will trigger the nuclear option and make the threshold 50, and that will further erode any sort of bipartisanship of the court, because now you don't need any Republicans. You can go straight up, appoint Nina Pillard, whoever you want to be from the D.C. Circuit, the most progressive nominee you can, Elizabeth Warren, whoever it is, and that becomes your next justice without a single Republican vote. And what's that do to our partisanship, right? We say, you know what? I'm going to nominate a judge who does not need a single Republican vote, or a single Democratic vote. That further degrades the process, and we'll be back here in 2 years talking about with Jeff as the spiral continues downward.
Mike, do you agree with Josh, and would that not be a remarkably heroic act of principle for the outgoing Republican, to recognize that President Clinton is going to nominate a more liberal nominee and not to confirm Garland?
Well, I don't know that I would call it heroic.
It would certainly be principle.
Yeah, it certainly would be. Well, it's the principle du jour. The part of the problem is that the reason for the inaction gets explained on different grounds, and I'm not sure. And so the principle itself, although again driven by politics, is a dangerous precedent to set, which is we're going to stop everything until the next president comes into power. I assume that principle could come into effect the moment after a new president takes her inaugural oath, which is, okay, we will simply let the next president make the choice. To paraphrase another justice from another case, it's a principle that has no beginning or end. And it's a dangerous principle. So I would, I think it is possible, entirely possible, in fact, quite likely, I think, Republicans in this current Senate will sort of remain steadfast and not allow any action to go forward on this particular nomination. But one of the things we might want to think about as we take a longer view is, what do we learn from this? And what's the takeaway from this? And I think, again, I'll come back to the point that this is an opportunity for leaders to kind of, in a sense, put their worst selves behind them, the worst past behind them, and find some other principle they think is one worth fighting for, one standing on. The last point I'll make is, look, I believe in separation of powers, I believe in checks and balances. You can't be a constitutional law professor unless you do believe in those things.
Sure you can.
Okay. I'm a constitutional law professor who believes in separation of powers. But I don't believe the Constitution is a suicide pact. I don't believe the Constitution necessarily requires us, in a sense, to completely allow everything to come grinding to a halt to a dangerous degree. So that's where, in a sense, I think what you hope is that people will find some basis for compromise.
Excellent. Related questions picking up off of Mike's idea. Someone asked, taking the Republican argument to the logical extreme, the Senate could effectively eliminate the Supreme Court by not acting on any of the Supreme Court nominations put forth by any president. And another questioner asked, is there a constitutional requirement to have 9 justices? Carrying the practice to the extreme, what would stop a scenario that you could end up with 7 justices, 5, or even 3? David, your response to that?
Well, at some point, the Supreme Court would lack a quorum, would be unable to act if it got to be too small. There's no constitutional requirement that there be 9. That's set by statute. This was the point of the Roosevelt court packing plan that Josh mentioned, where President Roosevelt proposed increasing the size of the court to change the outcomes of the case. That wasn't what he said, but everyone knew that was the reason. So I do think a logical implication of the argument that the Senate has the absolute power to withhold its consent would be the Senate could continue withholding its consent until the Supreme Court got to be too small to function. I mean, at that point, you might be able to say, well, you can't abolish the Supreme Court, and that's what they've done. But let me tie that into, if I can, with something that Josh said that I think was right and that Mike picked up on, about the extent to which this is being driven not by people in Washington so much as but by what's going on in the country, or at least by the perception of people in Washington about what's going on in the country. I do think at least many of the Republican senators who have joined this effort to obstruct Judge Garland's nominee, I think they're scared about being primaried. I think they're scared about losing their seats. I think that's why I think they know it's not the right thing to do. I mean, Senator Hatch, time and again, has shown he's a principled person. For example, he was chair of the Judiciary Committee. I cannot think other than that he is worried about how this will play back home. So I do think it requires a degree of, and heroism is too strong a word, but a degree of sort of willingness to take a risk with your office to stand up for principle. I think that's right. And to what extent this is, let me put it this way, having said that, I think these things feed on each other, that when people in power project this kind of very absolute, aggressive attitude toward the other party, when their attitude toward a president is not just, look, we disagree about some things, but basically he's illegitimate. He has no right to rule. He is abusing his authority. When the people in Washington and other sorts of elites project that, that filters down, and it legitimates that way of thinking. So while I do think that they are responding to what's out there, to some extent they have created what is out there. And when Senator McConnell rallied the Republican caucus to oppose, in bloc, oppose President Obama's health care plan, even though it's a Republican health care plan, conceived by Heritage, supported by Senators Dole and Grassley, and opposition to Clinton, and of course enacted in Massachusetts by the last Republican to run for president, when he rallied the party to block it absolutely and insisted on total party discipline, that conveys this kind of what Josh called partyism. That conveys this, it's us versus them. And now it's coming back to bite them. And I think to that extent, Josh is right that this is going to require some courage, but it requires some courage because of the doors that have been opened by the people in power.
Okay, two more points. First, the judge. Picking up on David's point, a questioner asks, isn't there a spirit pervading the Constitution that members of Congress be accountable for their actions, and aren't voters the most fundamental actors for which members can be held accountable? In that sense, why aren't the senators being rational in responding to their fear of losing their seats if they grant the hearings?
You know, what we're talking about,
What we're talking about here is not an academic exercise. We are talking about real people who are affected by these judgments and decisions. It doesn't really take much courage to do the right thing. With all due respect, David, and I agree with everything that you said, I don't call it courage. I call it doing the right thing. I mean, this is just a matter of fundamental decency and regard for a process, a simple hearing, so that the American people can see a nominee by the duly elected President of the United States vetted under questioning by those who are appointed to do that job. That's not courage. That's doing your job. That's doing the right thing. And so when we think about accountability, I think that's where the accountability should be reposed. And people are perfectly capable of through polling and through other means, letting legislators know what they think as a result of what they see at a hearing. Yes, accountability is always the core function or the core basis for democratic government. And thank God that it is. And there will be accountability here in one way or another. Senator McConnell, 56 minutes after the official announcement of Justice Scalia's death, made the statement that there will not be a confirmation hearing and that there should not be a nomination because the people should decide who the next Supreme Court justice is going to be. There is nothing in the Constitution, by the way, that supports such a proposition. But he and those who join that effort will be held accountable at some point in time. It is also true that there's accountability that goes far beyond that. We are all accountable to the extent that we remain silent in the face of this. I mean, we just heard that, that this is not high on people's list of matters when they think about the next election. Well, it should be, not just in terms of what Senator McConnell wants, who the next justice is going to be, but what positions do these representatives take in doing our business? This is our business that they are doing. What positions do they take, and what do we have to say about that? We'll answer in the voting booth. But it should not be this way. It should not have gotten to this point. And I don't think that there's any excuse that, well, it's somebody's fault and they've been doing this for this long and so forth. We have reached a point where, do you understand that there are people sitting on death row right now whose cases are not being taken by the Supreme Court because, and with very, very good issues. One is a gentleman by the name of Dwayne Buck, who was convicted in Texas and sentenced to death based on his race. The argument was that his blackness constituted a future danger. In Texas, you have to prove future danger to be eligible for the death penalty. That's been pending before the Supreme Court on a cert petition for 6 weeks now. This is the 6th week. They're not taking cases. This is paralysis of a sort. And it also affects others, many, many others. These are real live issues affecting real live people. This is not some academic question about, well, the text says this and that says that. Do your job. At least hold a hearing, for goodness sake, and then let the American people weigh in. And incidentally, while it may be true that this is not high on people's voting lists according to some results, poll after poll after poll since March has made abundantly clear that the vast majority of Americans, and I'm talking 60, 70, and in some polls 80%, including a significant number of Republicans, believe that the Senate should hold hearings. Why? Because, John Lewis, in accepting the Elie Wiesel Award, I listened to his speech yesterday, and he said, we may have all come here in different boats, but we're all in the same boat now. And it's true. We are all in the same boat, and this needs to be cleaned up.
Okay. Josh, in the bipartisan spirit, I am going to give you the last word.
Wow.
And, yep, the mic is yours. The judge has said whether or not there's a constitutional duty, it's just a matter of decency and accountability just to have a hearing, and that would let the American people decide, and by choosing not to, the Republicans are going to suffer political consequences. Your final words to persuade.
So let me make a totally different point. Confirmation hearings are a waste of time. Confirmation hearings are an absolute and utter waste of time. A colleague at the law school that Professor Strauss.
Stone teaches there too.
He does too. A colleague at the law school that Professor Strauss teaches at once referred to these as shams, as kabuki theater. Her name was Elena Kagan. In a review she wrote many years ago, she said that these hearings are a waste of time. They reveal nothing. Judges say, I'm going to follow the text. I'm going to follow precedent, but don't ask me anything because I won't tell you. Okay? Every nominee since Bork has done absolutely nothing because they don't want to go down like Bork did. What the heck is the point of a hearing? Merrick Garland will go up and say, I will follow the text, I will call balls and strikes, but I won't tell you anything else. What's the point? They're going to be absolutely a waste of time. In fact, Senator Toomey, your senator, actually met with Judge Garland recently, and he asked him about a case. He says, well, I can't really talk about that. He asked him about some other administrative principles. Oh, I can't talk about that either. Hearings are a waste of time, overrated. There's absolutely nothing we will learn from a hearing from Garland we don't already know. And what's the point of holding a hearing if we vote no anyway? So I don't care about hearings. They're utter and absolute waste of time. So actually fighting about this is not the issue. The issue is, will he get confirmed? The answer is no. Let's call it a day. Thank you, Mr. Rosen.
Ladies and gentlemen, we're going to continue this conversation. We have some senators who are interested in having debates on this very topic over the next couple of months, I hope here at the Constitution Center or in DC. So stay tuned. And in the meantime, please join me in thanking our panelists.
Thank you. Thank you, sir.
Thank you.